Welcome, everyone. Thank you for joining the webinar. We're going to take a minute or two up top, just allow folks to tune in, to hit that link, because it does take a little while if you're just looking at it now. But we do have a lot of great information tonight. We are going to be talking cottages, zooming in on that cottage. I know summer's over, but cottage is still a popular topic. And we're going to go through a couple of different pieces. Some great presenters will talk about gifting the cottage, selling the cottage. What if you include it in your will? What are co-ownership agreements? What's a promissory note? We'll cover all those different topics, as well as take a couple of questions. But Kevin, you know, we can't get too far into any presentation without making our lawyers happy, and they always want us to throw a disclaimer on the screen. So I'll have to put that up there. And maybe you can tell folks how the questions work while we have that disclaimer up.
Yeah, basically what goes on, I mean, by all means, if you're watching on YouTube or Facebook or whatever platform you're on, by all means, you can type questions into the bottom. Clinton and I will see these, and then we can bring them up to the parties that we have that are going to be doing our actual presentation. Feel free to write them down at any time. Now, we may be able to interrupt and give the question at that point in time, but most of them will be held to the end, and that way we can go. And of course, if you come up with anything prior now, that's great. If you come up with anything afterwards, please feel free to shoot an email to Clint and myself, and we'll make sure that those questions get on whenever they can.
Yeah, so the comment section, wherever you're watching, YouTube, Facebook, type it in the comment section so that way everyone can see it. And when it comes to cottages, often it's a real estate item because it is property, but it can also impact your estate, impact your will. And we're very fortunate to have two presenters that cover both of those areas. David is very much part of the Taylor McCaffrey Estate and Wills team, Larissa part of the real estate team. So we do have two phenomenal presenters. So without further ado here, Kevin, I think you and I should step aside and let the real estate experts and the estate experts work their magic. So I'll put Kevin backstage there. You guys able to pull up the presentation and we can get the show on the road?
Sounds great.
Okay. Hello, everyone. Let me just set up the screen.
Excellent.
Hopefully.
There we go. I see it. It's coming up. Excellent. So everyone can see that. I'll allow you guys to take over and go through the presentation.
Sounds great.
So before we get started, my name is Larissa Bagutsky. I'm an associate at Taylor McCaffrey. I'm here with my colleague, David Weeb. Whoa, far back. There we go. And like Clinton said, I work in the real estate department here at Taylor McCaffrey, and David works with the Wills and Estates department.
Yep, perfect.
So people often buy vacation properties, whether it's cabins or condos, but in this case, I guess we're talking about specifically cottages, with the best of intentions, that it will be a great place for you to get together with your kids and grandkids for vacation and holidays, that everyone will want to go there on their staycations, and that the property will be passed on to the next generation without any issue. Unfortunately, the reality of the situation, at least from our experience, is quite different. I always tell clients that death brings out either the best or the worst in people, and there's nothing more divisive than family property. Typically, there's one person in the next generation, so the property owner's children, who does all the maintenance work and goes out to the property all the time, and another person who's substantially less invested in the property. While it may make sense to leave the property to the first person under the will, that second person will likely want to ensure that they are benefiting equally as well. That feeling of being treated unfairly often has ramifications for all the beneficiaries of an estate. Which is why David, with his wills and estates background, and I, with my real estate background, thought it would be in the best interest to present this topic together.
Yeah, so a family cottage is really kind of that perfect blend of something that has some deep emotional value, but it also has tremendous financial value, and it's an explosive combination if it's not handled, carefully and thoughtfully. When people are fighting over money, there's often a cost-benefit analysis, there's a risk assessment, there's logical decision-making processes that can kind of lead the parties towards settlement. When we bring that deep emotional value of a family cottage into the mix, it can throw logic completely out the window. And we have clients who have been willing to accept very high costs to litigate cottage issues. So as a result, it's so important when we're doing planning, to do it in a way that reduces that risk as much as possible. During this presentation, we're going to briefly touch on a number of considerations when planning for cottage succession. We're going to talk about funding for taxes and expenses. We're going to talk about, selling the property to a family member with a promissory note, co-ownership agreements, maybe the pros and cons of joint tenancy. But I think the running theme that we hope you'll see throughout is that we have a lot of tools that we can pull out of the toolbox in order to help you achieve your goals for passing your cottage on to the next generation. But we can only do that if we make that plan well in advance. So it's really important to kind of do that work in advance so that we can kind of set you up for success. So with that in mind, the first thing we're going to talk about is funding the succession planning for taxes and expenses. So I'm coming from a wills and estates kind of background. So, when administering an estate, the first thing that the estate has to do is deal with the taxes and the debts. If an estate does not have the liquidity to pay those debts and taxes, then we need to liquidate assets in order to discharge those debts and taxes. That is just kind of the basic principles of this. So what that means in practice is if we don't have enough cash to pay the taxes, we might have to sell something, the family cottage as an example, or the family business, whatever it is. So, and you might be thinking, well, my taxes haven't been that bad. Probably not that, probably not thinking that, but, they're not too expensive. I have a little bit of cash set aside. The estate will probably be okay. I don't need to think about this too much. And maybe that's true. But estates can have way higher tax bills than you might have in your normal year. The reason for that is that this is the CRA's last chance to suck blood from you, and those vampires can always get a pound of flesh. No, but in all truth, the reason is that when you pass away, the Income Tax Act treats you as having sold all of your property to your estate for fair market value. So that triggers capital gains tax on all of your capital property. And there's exemptions and there's things we can do to move stuff around, but there might be a capital gains tax that we have to pay on death. And then additionally, if you have tax deferred investments like RIFs and RSPs, then the whole value of those accounts are deemed as income in your year of death. So income tax needs to be paid on those amounts on your terminal return. So, as a result of kind of these pieces of the Income Tax Act, we can end up in situations where the tax bill is considerably higher than what you might normally experience in any given tax year. And then another important thing to remember is that the estate is responsible for the taxes, not the beneficiaries. So if you say list your children equally as beneficiaries on your RSP, they're going to receive the benefit of that money, and your estate is still going to have to pay the taxes. So when we're doing estate planning, your family cottage is a very important part of that. But we need to build a plan with all of your assets in mind so that we can cover those taxes and expenses off and so that we're successful in keeping the family cottage in the family. My next slide here kind of talks about an example. So Jane is a widow. She has 2 kids. Jane wants to keep things simple and easy for her kids. Jane has a RIF with 300 grand, and she's got a cottage worth the same. The rest of her estate is of nominal value. If Jane names one of her children as the beneficiary of her RIF and then wills the cottage to the second child, that is an equal and even and simple division, right? Right, but wrong, right? So the issue is that the RIF, the 300,000, is going to get paid to that first beneficiary, and they're going to get the full benefit of the RIF, and the second child who gets the cottage is going to be dealing with the estate, is going to have the tax bill for that, right? And on a $300,000 RIF, we might have $125,000, $140,000 in taxes. So the cottage is going to need to be liquidated in order to cover off those taxes. So when we're doing this estate planning, we need to consider all aspects of your estate and build your plan to achieve all of your goals. You can't look at one piece in isolation. Jane's plan here is fine. It's achievable, but we need to build a plan that works kind of in coordination. I see there's a question there, Kevin. I can't hear you.
Yeah, Kevin was on mute.
There we go.
Alrighty.
Now I'm back. I was muted out. Yeah, someone wants to know, is it better to gift the cabin before you die or gift it in the will? Is there really advantage one way or the other?
I love that question because it gives me the opportunity to give the classic lawyer answer of it depends. It so depends on the facts. It so depends on what you're trying to achieve. It so depends on kind of what it is you're wanting to do. Like I said in the intro, kind of we have so many different tools to move your cottage through your family and keep it kind of generation to generation. But every person has their own kind of needs and wants and things like that. So if the answer to that question is come talk to us, and I'm certain that we have a tool for you, but I can't tell you which one it's going to be just yet.
Okay, so selling by way of promissory note. So this is actually something that might kind of blends into the question and discussion that David and Kevin were just having about, do you sell or do you gift the cabin in advance prior to your death, or do you wait until after? So, for example, say you want one of your kids to get the cabin specifically, but they can't afford to buy it from you. So effectively, it is going to be gifted in a certain way. If you want to give the cabin to one of your kids specifically, but you also know that they can't afford to pay it, you can give them the cabin by way of promissory note. So rather than having your child buy the cabin with cash or with financing, you effectively loan the money for the cabin to your child, and then they pay it back from their share of the estate's assets that would normally flow to them on your death. By proceeding this way, you can work together with your child to determine the value of the cabin, as well as any other terms for the promissory note, such as whether or not interest should be paid. Effectively, the cabin would be transferred to your child prior to your death, and then they would use their entitlement under the estate, which would go to him or her on your death or the death of the survivor between you and your spouse, to pay the loan back. As the promissory note doesn't have to be paid until your child gets their inheritance from your estate, it's effectively in advance. Their entitlement is canceled out. So for example, if their entitlement was $500,000 under your estate, and then the cabin was, so for example, say the estate is $1 million, 500,000 of which is the cabin, and then 500,000 of which is cash, they would get that $500,000 cabin, and then their sibling would get the cash value, so it offsets. I would recommend involving all your beneficiaries in these discussions so that nobody is blindsided by that arrangement. To the extent that you're able to, transparency is key. I could easily imagine a beneficiary having an issue with your child getting the cabin, a $500,000 asset now, essentially without paying for it, while your remaining beneficiaries have to wait for you to pass. Additionally, while the remaining beneficiary's entitlement will eventually be equal to the child who's getting the cabin, the remaining beneficiary might not find it equal in the moment because they have to wait indefinitely to make use of their inheritance, while the other beneficiary gets to own and take advantage of it now. Another thing to consider with proceeding by way of promissory note is that if you're trying to make your distribution equal, so each of your children get $500,000, either by way of the hard asset of the cabin or by way of cash, the cabin is likely to appreciate over time. So if you proceed by way of promissory note and then you don't pass for another 10, 20 years, the value of the asset that you've given to your first child, i.e. being the cabin, has greatly appreciated, whereas your second child is still only getting that $500,000 in cash. And so again, it's going back to that concept of equal is not always fair. Because the second child's entitlement will always remain static, and the first child's entitlement, being the cabin, will always appreciate.
Before we move too far on the promissory note, if I could jump in there, Larissa, just to recap, because a lot of great information there for folks. You did mention the family conversation, which we believe is fantastic. So we want to include everyone before you make any changes, just to make sure they're all on the same page. And then leading to the question, I imagine you're going to have to update your will if you go this route to make sure it's properly reflecting any promissory note that was put in place.
Ideally, yeah. I mean, hopefully your kids will, keep that in mind themselves, but it should be reflected somewhere, either in an addendum to the will or some other piece of writing. But if you're transparent and with your family, then whoever is the remaining beneficiary would be aware of this and could kind
Mhm.
of, call out their sibling. Oh, the state $500,000, remember? But the best way to structure that would be in terms of whether it should be included in your will or how it should be included would be something that David could help you with if you ever needed that.
Okay. And then quickly, there's a tax question, which I appreciate we're not accountants, but the understanding is the promissory note could allow you to break up a capital gain over a couple of years. If the promissory note was 5 years, you could perhaps break up a capital gain over 5 years as well. Is that true, or is that more for the accountant?
I would say that's probably more for the accountant. And it would also depend on how you're structured the promissory note. So ultimately, the promissory note is, and if your child is giving you a $500,000 promissory note, it's as if you've received that $500,000 in hand as of the date of the issue of the note. So I'd imagine, but again, please check with the accountant, that it would be as if you received the $500,000 and capital gains would be taxable then. But again, please check with the accountant.
Yeah, our understanding from the accountants we chatted with is you could perhaps do a forgivable loan over a couple of years and then allow you to break it up. But of course, your accountant wants to be on board. They're filing their return. You want to make sure that they understand the strategy before you implement something of this nature.
Yeah. So our next topic is the pros and cons of joint tenancy. And I always like to warn people when we start talking about joint tenancy that this is a weirdly complicated topic. This is the thing that keeps first-year law students up at night, causes lots of tears. Trying to understand this is pretty challenging. It can work simply, but how it actually works is less clear. So the key feature and the thing that I think you need to kind of understand fundamentally, the key feature of a joint tenancy is that when one joint tenant dies, the survivor by right becomes the owner of the whole property. So instead of a situation where, maybe I own half and Larissa owns half, and I can do whatever I want with my half, and Larissa can do whatever she wants with her half. In a joint tenancy, we both own the whole thing, and then when one of us dies, the survivor owns the whole thing alone. So when spouses create joint tenancies, the presumption at law is that the right of survivorship applies. But when parents and adult children create a joint tenancy, that presumption does not apply, thanks to the case that's listed on there, PCOR and PCOR 2007 from the Supreme Court of Canada, when the Supreme Court made everyone's life really complicated. The law presumes now that you're not creating a right of survivorship, but you are in fact creating a trust. And in that situation, the trustee is the adult child who is holding the property for the benefit of the parent, and the beneficiary is the parent. So what this means in practice is that when we create a joint tenancy, we need to be very clear and very consistent with our intentions. We need to be doing our paperwork, and we need to be documenting what and why we are doing it, so that when that right of survivorship kicks in and you can no longer speak to your intentions because you're presumably dead, the relevant intentions are clear, right? And it's not what your intention is 6 months later. It's not what your intention is 5 years later, right? It's what your intentions were at the time when you effected the transfer. So if you want to create a true joint tenancy, that means transferring beneficial interest in the cottage. That means you have to, when you transfer that interest, you're going to be triggering a capital gain and potentially capital gains tax. You're also, when you make the transfer, you're going to be triggering land transfer tax, right? So those are some of the cons, because you're bringing tax forward that would otherwise be paid later. Most people I know like paying tax later, not now. The positive on the flip side of that is that the person that you've transferred that joint tenancy to will own the cottage on your passing, right? So there's no, the paperwork is very simple for making the transfer, and they own it by right. So there's not, probate and things like that. In Manitoba, we don't have probate fees anymore, so that's not as big of an issue, but probate is slow. Courts move slow. But if we are inconsistent or unclear in our intentions when we create a joint tenancy, right? You transfer the cottage, have an interest in the cottage, but you retain the full beneficial interest. Maybe you don't pay the capital gains. You keep paying the full amount of the property taxes every year. You pay all of the expenses, and it's not 50-50. It's not being shared. If we're creating uncertainty about who owns what, you might accidentally create a bare trust. And when you do that, there are new bare trust reporting rules. You have to be filing a T3. Last year you did, and then you didn't, and this year you do, and we'll see if you do. But these new rules are in place for now. We'll see if they stay in place. But that creates an additional T3 return that needs to be filed. The other thing it can create is a lot of litigation, because when there's uncertainty and we've got that piece that has a deep emotional connection and also a lot of financial value, litigation is always creeping under the scenes and is waiting to pop up if we're not careful. So I want to circle back to that holistic. We need to be, if we're going to use joint tenancy as a method to transfer the cottage, that's great, but we need to be doing it with kind of your whole plan in mind. Kevin?
Yeah, so you're not recommending not putting an adult child on it, but if you are going to do it, you need to jump through the right hoops to make sure that right of survivorship is done and it's not a trust. Is that how we're understanding
Exactly. That's exactly right. We don't, it's totally fine. Like, this is a useful tool some of the time, not all the time, but some of the time. But it's a tool that can be, that we can, if we misuse, it can be a little bit dangerous, right? Think about, a power tool, right? If you're not using your safety guards and things like that, you can lose a finger pretty easy, right? Like, we can kind of create a mess if we aren't careful when we're using this, when we're using joint tenancy as a planning tool. So, like I said, some of the time it's the right tool, other times it's not the right tool. It always depends on your circumstances. And if we're going to use it, we want to make sure we use it in a way that is not creating that uncertainty.
Okay, perfect. Thanks.
Yeah.
That actually flows really well to our next point, which is the concept of the co-ownership agreement. So if you decide that you want to proceed with entering into a joint tenancy agreement with your children, one way that you can kind of establish that, no, they actually were co-owners with me, and to try to kind of get around this presumption of the trust, is a co-ownership agreement. So co-ownership agreement is a legally binding document that sets out the terms and conditions as to how the property will be owned by those who use it. Some of the things that can be considered is financial contributions, usage rights, exit strategy on death or incapacity, first rights of refusal for sale, for example. So for example, if you have two kids and one of them is super into the cabin and the other isn't, can the one who's not into the cabin use it as a rental property? Can the one who is not into the cabin contribute less overall for its maintenance if they're getting less use of it? What is the process arrangement for buying you out of your share in the cabin should you die or become incapacitated? Should the kid who really makes use of the cabin get first priority to purchase above the kid who is less into the cabin? These are all issues and questions that can be answered and laid out very strategically and very neatly in a co-ownership agreement. A benefit of the co-ownership agreement is that it can be prepared at any time. So you can prepare it now, even if you bought the cabin 20 years ago. The co-ownership agreement usually also sets out a dispute resolution mechanism, so that if your two kids disagree on what to do with your cabin once you've passed, they can reference the agreement and its terms, which will likely have been agreed to by everyone when cooler and less grief-stricken heads prevail. The con to the agreement is that you are giving up some of your ownership rights to your children. For example, if you want to rebuild the dock or deck on your cabin, you may need to get your children's consent, depending again on what the agreement says. There's also the risk that someone doesn't hold up their end of the deal. For example, if all costs are split equally, what happens if they don't pay their bills or overuse or damage the cabin? Because you are still on title, these repairs and charges are still your responsibility. So, I mean, the co-ownership agreement, if someone is offside of it, I guess could act as a mechanism because it is legally binding that you could sue on, but that's probably not something you want to bring into a family dynamic. So it is something that you need to consider, that in exchange for having some certainty, you are also giving up some control. I think we are kind of right on time, and we are now onto the question period.
Yeah, we'll certainly leave an opportunity for folks to ask questions. Before we finish the prior slide, though, if you don't mind going back for just a moment, on the co-ownership agreement piece, and I'm kind of connecting dots here from the prior part of the conversation, saying you want everyone on the same page, you certainly want a holistic approach. I imagine a good time to talk about that would be when you're talking about your general cottage succession plan with the family. So folks can understand if they inherit it, it's not just a free gift. There's going to be responsibilities, there's going to be costs, and they have some kind of idea of how they're going to use and cover all those items. I'm guessing that would be a good response.
Yeah, that's definitely the way to, like, a co-ownership agreement could set out all of that. And we can tailor it to whatever your specific needs are. There isn't one like specific co-ownership agreement template that you can just go and applies to every situation. It depends on the facts of your specific case, but yeah, those are all things that could be considered.
Yeah, so an example, for example, if you have two brothers and they're sharing a cottage, well, a co-ownership agreement might help them kind of fine tune exactly how they're going to share that cottage. And you can do it at any time, but maybe perhaps someone passes away or inherits the cottage. That would probably be a better time to have that discussion.
Yeah, or I know I have an older sister. Sometimes, parents' influence, getting them to referee our fights even at our age, in their mid-30s, is always helpful. So maybe it's something you want to do to take effect on your passing between your two siblings, so that you can be there to referee any arguments that they may or may not get into, as siblings often do.
Yeah, perfect. Well, I appreciate adding the clarification there. I'll pull Kevin back on as well. So the intention was to provide an overview on some of the key pieces when it comes to cottage succession, looking at the promissory note, the co-ownership agreement, the joint tenancy, as well as a few of the other topics there. If you do have questions, now would be a great time to add anything you wanted elaboration on or something we didn't cover. You can type it into the comments section, whether you're on YouTube or Facebook, wherever you're watching. Feel free to use that comment section to ask a question, while we do have David and Larissa on the line here.
There is one question I've seen that's come in. It deals with blended families. You have a lot of those now. Say one parent owns a cabin and it's strictly in his name. He wants to will it to his children. He passes. What happens in that case if the new spouse or something goes after it compared to the kids? What kind of a legal binding or legal situation would that create?
Yeah, so blended families are complicated when it comes to estate planning, right? Because essentially how it works when one person in a spousal or common law relationship passed away, is that the surviving spouse can essentially, not a perfect analogy, but can essentially apply for kind of a post-mortem divorce, right? So there's a Family Property Act process to divide up the property, right? Similar to how it would be divided up if while you're both alive. There are some additional rules and all that. So when we're doing estate planning for blended families, an important thing to think about is whether or not we want to have a estate planning agreement, or kind of it's a bit of a marital agreement, where we kind of set out, these are going to be the terms of our estate planning. So my kids are going to get my share of the estate. Your kids are going to get your share of the estate. We're going to agree to this. We're going to waive our rights to this. We're going to waive our rights to that. Whatever. We can design that and kind of plan that out in advance. Another really useful tool. Taylor McCaffrey has a great family law department. You can do a cohabitation agreement or a premarital agreement. That can kind of govern those terms and kind of set out those rules. So, there's a lot of ways to plan for that in advance. If we don't plan for it in advance, it's going to get messy, right? We got to figure that out, and it can become complicated to make sure that things land the way that we want them to. When blended families fight, it can be really spicy. So, I'd really encourage you to, do that planning in advance when everyone's, like we talked about with cooler heads. That's the time to do the planning, not when you're right in it. So, again, lots of tools that we can use to help build the plan, but if we don't set them up in advance, they are not available after the fact.
Yep.
Yeah, limited planning tools after someone's already passed and the cottage is going through the estate. Yeah, much harder at that stage.
Exactly.
Yeah, I did get a note here. I know we're jumping topics, but from an accounting client that was watching on the promissory note item, in their view, they thought depending on when you get the cash, you might be able to break up the capital gain over the structure of the promissory note. So if you don't get it all at once and you get it kind of in chunks, you're allowed to match your taxation to when you actually get the cash. But again, that would be really more for the accountant. If you're considering using the promissory note, you definitely want to include your lawyers and your accountants before you get anything like that set up.
Yeah, and depending on when the the promissory note is payable. So if it, like Larissa was talking about, it being payable after you pass away, we always have, with estates, we have like kind of a 3-year window where we get preferential tax treatment. So we might want to keep that in mind. We definitely want to get the accountants involved to see if that it's what's called GRE status. We'd want to know if that GRE status, if it's over 5 years as an example, we're outside that GRE time. Are we increasing our taxes? I don't know the answer to that. I'd get our tax guys to help us.
Okay. Yeah. Well, lots of nuance here, and of course, your exact situation, you do want to talk to the professionals before you act on the general comments. But we had another question come in asking about tax rules on gifting a cottage to a child before death. I know that's a big topic, but if you can comment on gifting a cottage to a child before death.
Just generally?
Yes, that was the question. What are the tax rules on gifting a cottage to a child before death?
So I mean, any capital, like when you gift, the cottage gets transferred in CRA's mind at fair market value, right? So we're going to see a capital gain.
It would trigger a deemed disposition. So
right, it's going to dig exactly right. So that's going to have to be dealt with. Land transfer tax is also going to trigger because we're transferring. So I mean, those would be the two that jump off the page at me. There's no, gifts aren't subject to like income tax or anything like that. So the beneficiary or the recipient wouldn't have any tax to pay, I don't think. Larissa, anything else that you would jump off the page at you?
I don't know that a minor can own property.
To a minor? Sorry.
Well, just
child,
to a child. I was assuming an adult child.
Okay, I assumed a minor
child would be able to own a cottage.
Yeah, if you want to give your 6-year-old a cottage, we need to have other conversations.
No.
Yeah, so I'm like, probably some sort of trust arrangement would have to be maintained, because I don't think a minor can, if you're speaking about minors, a minor can't hold a property. So then you need to consider what kind of trust arrangement you'd want to enter into.
Yeah.
Yeah, so if it's an adult child, well, in either case, it sounds like, little recap here, the recipient might not have any tax implications. The person doing the gifting who owned the cottage could trigger a deemed disposition of land transfer tax, assuming that it goes to an adult child. If it goes to a minor child, it could get far more complicated. You could have trust arrangements included in that.
Yeah.
I mean, typically land transfer tax is payable by the purchaser.
Oh, okay.
So that may be, and I mean, you can Google it. There's a calculator for Manitoba properties, and it's based on their value, what the land transfer tax is. So you can figure it out. And again, it may not be something that's affordable for the person you want to gift it to, but typically the purchaser does pay for the land transfer tax.
Okay, good to know. Yeah, so hopefully that answers the question. If there are additional questions, type them in the comment section there. We're still hang on the line for a few more moments.
One other one might be, is there ever a time that you'd recommend more or less selling? Like, let's assume that mom and dad pass it off to their 3 kids, and each of their 3 kids has 2 kids. So by the end of that sort of time frame, trying to get this sorted out between 6 kids might not be the easiest thing to do, or?
Yeah, that's, I think, where the co-ownership agreement that Larissa spoke about can be really useful, right? Because we can kind of set out what is the terms of what's our exit strategy? Like, when do we all walk away, right? Is there an option for someone to buy out people's shares? Is there what are the kind of the pieces of this puzzle and how's that going to work? When do you this is always a funny thing when you got like the blend of like law and personal, right? I would have a hard time recommending to someone, hey, listen, it's time to sell your family cottage. I know you have a lot of great memories and you love this place, but you could have 180 grand instead. Like, you could have your 1/17th share of the cottage. Like, that's a hard conversation to have, right? I'm not sure I'd ever recommend it, but like, certainly we're going to bring it to your attention as an option. Because, I mean, yeah, it can be really complicated. At points you kind of do need to consolidate the list of who's on the title and who owns the property, and having a co-ownership agreement can be a great way to make sure you stay with a tight ownership group.
That's perfect. Yeah.
I mean, effectively, yeah, the co-ownership agreement almost turns your family property into a family timeshare-ish, right? You have, in the timeshare, you have your set weeks, you have your set fees, everybody's responsible for whatever. And so if you can have, in timeshares, people get 1 week out of 52. I mean, you could, I guess, have 52 family members participate in it. That's its own set of challenges, obviously, negotiating who gets what weeks and who pays what bills, but you could have a lot of people involved in the co-ownership agreement if you wanted to.
Okay, another one that came in here is more on the probate side, asking if the cottage is in one name, and they gave an example. In this example, it was the wife, so it's in the wife's name. They pass away, and it goes through the will to the husband, then the husband passed away and goes through the will to the next generation. Is there probate each time? That was effectively the question?
Yeah, so anytime we have to transfer land, we need someone to have the authority to sign the land transfer documents. So we need either a probated will, or we need letters of administration from the court. So there are going to be things like, it has to be done each time. Now in Manitoba, so if the land is in Manitoba, there's no probate fees. I mean, you have to hire the lawyer and do the paperwork and the rest of it. So there are some fees. I don't want to like hide the baseball here, but there's no tax. There's no death tax in Manitoba anymore. There used to be, and in Ontario, where lots of people have cottages, there are probate fees, and they're quite prohibitive. They're quite expensive. Dying in Ontario, very expensive. Don't recommend.
Don't like
So it's important to know where your land is, because your estate is governed. We're getting into conflict of laws. We're getting really deep into law school. Your estate is governed where you are resident when you die, but your land is governed by the laws of where it is. So your estate might be a Manitoba estate because you live in Winnipeg, but if you've got a cottage in Kenora, you now have an estate in Manitoba and an estate in Ontario, and the rules are different for those two estates. So it's important to do planning holistically. We want to look at both of those jurisdictions. We want to make plans that are going to cover both places, that are going to be valid in both places. We want to make sure that we're doing sensible planning. So so the probate fees part, I think, is important to kind of think it's not as bad as it used to be in Manitoba and Ontario. We really do want to find a way to avoid those the probating.
Yeah. Sorry. Go ahead, Larissa.
The exception to that would be if you are joint tenants. So
yes.
Right now, it sounds like in Clinton's example, or the example that was come in, it was just in the wife's name, went just to the husband, went just to the kids. But if husband and wife are joint tenants, then you don't have to file for probate.
Yeah.
If kid and husband were joint tenants, which again, we kind of touched on those issues with the presumption of trust when that happens, but you wouldn't have to file for probate. So that's something to keep in mind as well, but you just have to tread that line really carefully to make sure that once it goes from husband to kid, that it does stay as a property and not as a resulting trust.
Yeah, that's a really good, and Larissa, you can correct me if I'm wrong, but when you transfer from one spouse into joint names with the second spouse, I don't think you trigger land transfer tax in Manitoba anyway.
No, I don't.
Right. So
believe so, no.
So that's kind of a good way to skip. You can skip the probate. You can skip the land transfer tax. I don't believe there's a deemed disposition for the capital gain. So I mean, we can kind of skip a lot of steps there. Now, there's other things, there's risks associated with that. If you've not gone on title because you're a professional and you're worried about professional liability, or you've got creditors, or you've got different things going on, maybe we don't want to do that. But it's an option. It's just to keep in mind.
Good. Yeah. Lots of nuance. I appreciate the responses. If you do have another question, we've had a couple of them come in, which has been great. If you have more, type them into the comment box. We'll hang out for a moment or two more before we go. Yeah. Good. And you can see, I think it's on the thank you slide there, both for David and Larissa. They have their email and their phone number. So, of course, if you need them to help with your situation, for all the different planning tools that we talked about, feel free to reach out. I'm sure they'd be happy to hear from you and to help you on as a client. No more questions are coming in, so perhaps we can leave it there for tonight. We appreciate you guys doing the webinar, going through those details with us. Again, if folks have questions, you can see the contact info on the slide. Please reach out to David or Larissa. And I think we can leave it there, Kevin.
That sounds excellent. Thank you very much for all the help you provided us and the clients, and we hope that this has been helpful for everybody else too.
Thanks for having us, guys.
Have a good evening.
Good night.
Thanks.